Welcome back. Today, we are diving right into a seriously dense legal labyrinth inside the INA. That's the Immigration and Nationality Act. And we're going to reveal a frankly bizarre trap for job seekers. If you're navigating the US immigration system, you know the stakes are sky high, right? Well, today, we're zeroing in on INA 212A4. It's the public charge rule, and we're looking specifically at a hidden catch in employment-based visas that completely blindsides even the most seasoned professionals. Let's get into it. So think about this. Could getting a job from a relative actually ruin your US visa chances? It sounds like a total paradox, doesn't it? You'd naturally assume that having a successful family network willing to hire you in the States would be the ultimate advantage. But nope. Under a very specific clause in the INA, those family ties don't fast-track you. They actually flip the script entirely and can trigger a strict visa denial. Wild, right? Okay, here's our roadmap for today. 1. Navigating visa ineligibility laws. 2. Defining a public charge. 3. The 5 evaluation factors. 4. The employment-based catch. And finally, 5. The affidavit of support.
All right, moving into part 1, navigating visa ineligibility laws, understanding the foundation of the INA. As you probably already know, the INA acts as an absolute gatekeeper. Consular officers aren't sitting there just looking for reasons to approve you. Actually, they're legally bound by Section 212 to aggressively screen applicants against a massive list of strict statutory ineligibilities. It's like a minefield. If you hit a tripwire, no visa gets issued, period. End of story. Which brings us to part 2, defining a public charge, the core concept of INA 212A4. Now, the crucial point you absolutely need to understand here is that this denial, it's not based on hard math. It's actually highly subjective. Notice the exact phrasing in the statute, in the opinion of the consular officer. That's huge. It's a predictive assessment. If they believe you are likely, at literally any time in the future, to rely on the government for support, you're deemed inadmissible as a public charge. So how do they predict that? Let's look at part 3, the 5 evaluation factors, breaking down the statutory assessment. To predict your financial future, Section 212A4B actually forces the officer to weigh 5 mandatory factors. We're talking about your age, your health, your family status, your assets, resources, and financial status, and finally, your education and skills. Think of it kind of like a giant set of scales. If you're maybe a bit low on cash resources today, having a highly specialized STEM degree might be the exact counterweight needed to tip the scale back in your favor in the officer's opinion. Okay, now for the tricky part. Section 4, the employment-based catch, the hidden trap in Section 212A4D. You know, most people think the public charge rule only haunts family-based visas. But here's the massive divide when it comes to employment visas. If a huge faceless corporation hires you, that high-paying job offer alone usually just crushes any public charge concerns right out of the gate. But the second you get an offer from a business owned by your own family, boom, the INA throws up an immediate statutory stop sign. Just look closely at the exact legal text from Section 212A4D here. Specifically, look at that parenthetical, or by an entity in which such relative has a significant ownership interest. Guys, this is the trap. Even if you're hired by a wildly successful, legally distinct corporation, if your parent or sibling owns a significant stake in it, you are automatically presumed a public charge risk. The bureaucracy is literally penalizing your family connection. But don't panic yet. Section 5, the affidavit of support, processing the legal solution. Thankfully, the INA does provide an escape hatch here. To bypass this family ownership trap, your relative has to execute an affidavit of support described under Section 213A. But make no mistake, this isn't just some friendly corporate letter of recommendation. Absolutely not. It is a legally binding, fully enforceable contract where your relative personally guarantees your financial backing, basically so the U.S. taxpayer doesn't have to foot the bill. So, neutralizing this threat requires following a really precise legal playbook. First, you got to do your due diligence. Investigate the corporate structure of your sponsor and see if a relative holds a significant ownership interest. If they do, step 2 is acknowledging that the 212A4D trap is officially triggered in your case. Finally, step 3, move to proactive compliance. Get that Section 213A affidavit executed and put it front and center in your application package. You simply cannot bypass this requirement if you want to get approved. So, Bringing it all together, the INA is a vast, incredibly rigid framework. And as we've seen today, even what seems like the ultimate advantage, a lucrative job offer from a successful family business, can trigger a technical denial if you're caught off guard. So take a hard look at your sponsorship structure, evaluate those 5 factors we talked about, and ask yourself this: if a consular officer evaluated your family ties today, would they see a promising, self-sufficient employee or a public charge risk? Thanks for joining me on this explainer, and I'll catch you next time.